A few clause, again, like in the Bakken, where you say, listen, you know you're going to get the Bakken, and if that's what you produce from, and that's all you produce from, then you're going to drop out, the Three Forks or the Sanish or whatever else is possible to produce if you're not producing. So again, like I said at the start, it depends on your location. We'll now go through lease form, and this is in, like I say, it's in your materials too. What I want to point out here is that the yellow on top there, which I've got highlighted, it says foreign in consideration of $1 and other dollars. So the bonus isn't stated. The total bonus amount of, say you had, say the bonus was $50,000. It's not stated, and it's not stated on a per acre basis either. The second yellow part there is important. I want to point out is that a rancher who signs an oil and gas lease, when that lease is signed, is granting all those rights to the oil and gas lessee. Not just the right to come in and explore for oil and gas, and drill for oil and gas, and produce oil and gas, but of course to build well sites, to build roads, to install pipelines, to put in power lines. All those rights are going to be stated in any oil and gas lease I've seen. Also want to point out that right below that yellow there where it says about 4 lines, it says, and containing blank acres, more or less. If the oil and gas company is leasing all the land the rancher's got, and the rancher has 5,000 acres, 5,000 acres will be put in there, even though the rancher may only own 1/2 of the mineral interest. You don't make the reduction in that acres right there. That's the gross acres. There is a clause we'll go over later on, which takes care of the fact that the rancher might not own the entire mineral interest. This is paragraph 1 of the lease, and the highlighted area here says, okay, for a term of blank years. If whatever's put in there, that's the primary term. It's, like I say, you'll see 3 now, you'll see 5 sometimes. And then maybe it's obvious, but the shorter the primary term, the better it is for the lessor, for the rancher. Because then the lands are going to come up for leasing again, and it also puts more of a burden, a time constraint on the lessee to drill. Because it's a 2-year primary term, they're going to have to get in there and drill. The longer the primary term is what the lessee is looking for. They'd like a 10-year, at least a 5-year. And then the rest of the highlighted words there, and as long thereafter as oil or gas or whatever nature or kind is produced, that's the secondary term. The lease will be held so long as there is production. Number 2 at the top there says this is a paid up lease. Makes it very clear. And if you notice back at the first page here, most of the leases aren't going to have that heading at the top there, paid up oil and gas lease form. I put that on there. But if you look right at the upper left-hand corner, it says Producers 88 paid up. Producers 88 is a term that used to mean a specific type of oil and gas lease. Now there's thousands of variations of the Producers 88, but most all leases will still say Producers 88 and then have some version in the upper left-hand corner. But if you look there, that's a fast way to tell if it's a paid-up lease or not. In paragraph 3 is a royalty. This lease provides for a 15% royalty. And in sub B there, where I've highlighted on gas, and then 15% of the product so sold, this one says, after deduction of all costs and fees included in, these are the important things, gathering, compression, transportation, treatment, that can be BTU enhancement, dehydration, processing, and other measures. So under this lease, the oil and gas lessee is going to deduct all of its costs in getting that gas to market. And that doesn't mean that the lessor did a bad job of negotiating. It could be that's what the lessee said, we have to be able to do that. Or we're going to be paying a royalty we can't afford. And number 4 is the shut-in clause. And there's where it says that in order to shut a well in, you'll pay $1 per year per net mineral acre. And this clause says where oil or gas from a well can't be, is going to be shut in. And remember I said you're going to want to consider should there be the ability to shut in an oil well. And this has no time limit on it. Time limit is something that you would want to consider negotiating, asking for at least. Number 5 is what's called the lesser interest clause. This is where I said in the start of the lease, you'll set out the gross acres, all 5,000, even though the rancher might only own an undivided 1/2 interest in the minerals, so therefore only owns 2,500 net mineral acres. This clause takes care of that. Every payment then to the rancher is going to be proportionately reduced according to what he does own. He's not going to get, in this case, 15% of all the oil from any well that's drilled on his premises. If he only has half of a mineral interest, he'll end up getting 1/2 times 15%. This clause and it takes care of bonuses, it takes care of the shut-in royalties, it will proportionately reduce all payments. 13 is the answer to top leasing, which you're starting to see these more and more. And that just says that if during the term of this lease, during the primary term, you get an offer from somebody else to lease in the event this bottom lease drops out, then the lessee has 30 days to meet that offer. $15 is where, as you'll see this in most all leases, it's a warranty clause, where the lessor is warranting and agrees to defend title. And I recommend that this be stricken, and all oil companies that I know agree to strike it. The oil company is the one that's checking the mineral title, not the rancher. So if they come up with a conclusion as to what the rancher owns for minerals, it's their conclusion, it's not the rancher's. So the rancher shouldn't have to be warranted. Move on a little bit, and Bob covered some of this, so I'll go through it fairly quickly. But you're going to see in every oil and gas lease, and the one in the book, that the lessee has the right to pool the lessor's mineral interest, and he has the right to unitize it. And a little background of what pooling means, and we'll get to that. The statewide spacing for oil wells is 40 acres. That means if you drill an oil well in an area that has not been spaced by the Board of Minerals and Environment differently, the statewide spacing by administrative rule is 40 acres. So if you hit a discovery, your well is successful, and you find oil, then the spacing for that is 40 acres. If you never drilled another well, that spacing is 40 acres. For gas wells, because those reservoirs are usually bigger, it's 640 acres. But once you do make a discovery of oil or gas, if you want to drill other wells adjacent to that well, which is an offset or a step-out well, you have to space the area. And you can space just a small area around your discovery well, or you can space a fairly large area. You need some geology and reservoir characteristics to justify the area that you want to space. Once you say, and typically oil wells in South Dakota are spaced on 320 or 640 acres. Gas wells the same, 320 or 640. And spacing is, if it's contested or not, what the result is, let's do, say that you're doing a space, you want to have one well per 640 acres, whether it's gas or oil. And you give the mineral interest owners all get notice of those that you want to space receive notice. They have an opportunity to appear. Adjacent landowners get notice. They have an opportunity to appear. It's published in the paper. And if there is a contest, then there's a contested case hearing before the Board of Minerals and Environment. The issue will be, does the geology and reservoir characteristics justify the spacing that's sought? Pooling is the result of spacing. In my example, I used a section. And say the oil and gas operator who made the discovery says, I would like spacing units that are one section in size. And we'll drill one well in that section. Well, all the mineral interest owners in that section will share in the production from that well. They're pooled into that well. And they share production based on surface acres. So if there's, here's a little bit of a cartoon example of, if this is a section, right there, and A is the northwest quarter. And what I've got here, this outline is a pool of oil. And say the well is drilled down here in the southeast quarter. Everybody in this section is pooled and will share in the production from that well, including the mineral owner up here and say the northwest of the northwest, where the pool doesn't even go. The pool of oil, in fact, doesn't go there. But there's no way to know that for sure. It's in South Dakota, it's 9,000 feet deep. You can't go down and look. So what pooling does is say, well, the fairest thing to do here is we're going to, this mineral owner, say, the guy in the northwest of the northwest, which is 40 acres, and it's 100% mineral interest in those 40 acres owned by Rancher A. Well, Rancher A is going to get his share of the oil from that well in the southeast quarter, even though the oil may not in fact be under it. But there's just no other way to do it. And what pooling does is then the guy that owns the northwest of the northwest doesn't have to run out and drill a well for himself. It might be a dry hole, but he doesn't have to drill a well to protect himself. He gets to share in the production from the well that's in the spacing unit. And it's viewed to be the fairest way to do it. Typically, probably reservoirs of oil aren't going to look exactly like that, but that's what I wanted to show you about what's the effect of spacing. The effect of spacing is pooling, and everybody shares according to surface acres. There's two types of pooling. Once a spacing unit has been set, all of the mineral owners, or usually it's going to be the lessees of the mineral owners, can agree upon drilling a well, and they'll pool their interests, and all the mineral lessees will share in the cost of the well, drilling the well. So, say there's 640 acre spacing unit, and there's two mineral owners, and they each own 50%, and they've each leased. Those mineral lessees can say, let's drill a well, and we'll each pay half the share of the cost of the well, and we'll see what we get. That's voluntary pooling. Usually they'll enter into what's called a joint operating agreement. But what if they can't agree? What if those two mineral lessees cannot agree? And we'll call them mineral lessees A and B. So the lessee of A says, I want to drill a well. I'm pretty sure we're going to hit here. But the lessee of mineral owner B says, nope. Well, the law is set up so that mineral lessee B, the reluctant lessee, can't stop drilling just because, can't prevent drilling just because they don't want to pay. the first mineral lessee, A, can go in front of the Board of Minerals and Environment and say, I want to drill a well, and B doesn't want to, so I want to force pool it. And the board has the authority to do that. It can enter a compulsory pooling order or a forced pooling order, and it'll set the terms under which the pooling occurs, the forced pooling occurs. For lessee B, it'll set forth two alternatives. It can say, B, you can pay your share of the well as it goes down, as it's drilled, or you can elect not to if you don't want to. And if it's a dry hole, you won't pay a dime. But if it's a producer, not only will you pay your share of the well out of production, you will pay a 200% penalty. That's the top, that's a 2A there. 200% penalty for a mineral lessee. So if the well costs $2 million, then B's share of the well would be $1 million. And in addition, not only does it have to pay that, it has to pay $2 million more as a penalty, so it pays $3 million. And that risk compensation goes to the person who paid, the lessee who paid to drill the well. Now, in that case, the royalty owner of mineral lessee B is not penalized because he will get a 1/8 royalty is paid to him even during payout of that penalty, because we don't want to penalize the lessors whose lessees didn't agree to drill a well. The royalty is taken out and paid anyway. There's one other version you can have, and that's the risk penalty for a mineral owner is less than the 200%. That's only 100%. So say we don't have any mineral lessees, and we still got the 640 acres, and we got mineral owner A and mineral owner B. There's no lessees. And A wants to drill. Says, I don't need to wait for an oil and gas lessee. I think we can drill a well ourselves. So A wants to drill, B doesn't. A can go in front of the Board of Minerals and Environment and say, I want to drill a well, and I want to force pool B, who doesn't want to. Again, in this case, there's going to be three alternatives that are given to mineral owner B. The board will say, well, you can lease to A on reasonable terms, and here's what they are. Or, number two, you can pay your share of the well on the way down, if you want to, and you'll participate as a 1/2 owner. Or three, you can pay nothing. And if it's a dry hole, it doesn't cost you a dime. But if it hits, not only will you pay your share of the well, you will pay a 100% penalty. So again, if the well costs $2 million, then mineral owner B, who didn't pay going down, he'll have to pay that $1 million. Plus he'll pay a risk compensation penalty of another $1 million. He will also get a 1/8 royalty during payout. So he's not completely shut out while his share of the well and the risk compensation are being paid. He's going to get a 1/8 royalty. I'm starting to see mineral owners who take that option. Because if it's a dry hole, it doesn't cost you anything. And if it's a producer, yeah, you're going to pay a penalty. You're going to pay a risk compensation penalty, but you're going to get a 1/8 royalty, and when payout is reached, you're in there for half the well. In the situation that I gave you, where you got two mineral owners. So if it's going to be if the odds are good that it's going to be a really good producer, mineral owners now are getting a little more sophisticated, and they might say, force pooling. You never used to see that before. So it's a developing area.
Taxes don't apply with the lessee in the owner?
Yes. Yeah, he's asking the question, does it apply with say you've got mineral owner A leases, mineral owner B doesn't. Yes, you can have forced pooling between those. And if you force pool mineral owner B, who didn't lease, he only has a 100% penalty. But if he force pools the lessee of A, that lessee will have a 200% penalty. Yes?
What happens
The question was, what if there's forced cooling and a well is drilled and it is a producer, but it's not a good producer, and it either isn't going to pay back the costs or it's going to take a real long time. It's the same. If the well never pays out, the entity who was forced cooled never pays a dime, because all of their cost of the well and all of their penalty is taken out of production. And the reason for the penalty is it's compensation to the person who does drill the well for taking the risk. If it's a dry hole, they eat it. So it seems fair that if it's a producer, they get compensated for taking that risk. Okay, now we'll go to surface use agreements and why you need them. And they are as important to negotiate as the oil and gas lease. To start off with, there's a surface estate and a mineral estate, and between the two, the mineral estate is dominant over the surface estate. And the reason for that is it doesn't do you any good to own the mineral estate if you can't get the minerals out. And for oil and gas, about the only way you can get the minerals out is to get on the surface and drill a well. So the mineral owner and the mineral lessee has that right. They have the right. And now you're usually talking about a severed mineral estate, where the mineral estate is owned by somebody and the surface estate, the rancher, owns the surface and it's somebody different. So the owner of the mineral estate or the lessee of the mineral estate has the right, even against the surface owner's wishes, to go on the surface and explore for, develop, and produce the minerals and use so much of the surface as is reasonably necessary to do that. That causes problems when the surface owner is not going to get any of the production, isn't going to get any royalty. He does not like to see that drilling rig come over the hill. So, and in Hardin County, they started severing minerals there in the 1920s. So there's many situations where the mineral interest is completely severed and the rancher doesn't own any. In the instance, we'll first go through the instance where well, let me cover 45.5A first. Our South Dakota legislature enacted a law, which I've cited there, 45.5A, I don't know what the title is, Surface Damage Compensation Act, maybe. And it goes through numerous provisions that say the surface owner should be compensated. There is no requirement, however, that the operator pay surface damages to the surface owner prior to entering to drill. And we're just talking about oil and gas here, so we'll talk about drilling. And I don't think it could say that, because if it said you have to pay damages prior to entering to drill, then the mineral estate wouldn't be dominant. You can enter, but what this law says is you should pay damages. Let's now go to how surface use agreements maybe can address these issues that we've talked about. If the rancher owns the surface and the minerals, then the time to enter into the surface use agreement, well, I've got the question there, when should you enter into it? Is it the same time that you're negotiating the lease terms, the oil and gas lease terms? Because if the rancher signs the lease, remember all those activities that the lessee can do? You can enter on there, drill wells, build roads, build pipelines, build power lines. Once the lease is signed, the lessee has those rights. So if the rancher wants compensation for those activities, in addition to being paid a royalty under the oil and gas lease if production is obtained, then you need to negotiate the surface use agreement at the same time that the oil and gas lease is signed. And what oil and gas, or what surface use agreement should cover, are everything I've got itemized there. What's going to be the compensation for well sites? Is there going to be a one-time payment and an annual payment for well sites? How big can well sites be? Do well sites need to be fenced? Number 2, what's the roads? What's the compensation for roads? Usually it's on a per rod basis. And is there only a one-time payment for roads, or is there an annual payment for roads? For example, you could have a $5 per rod initial payment and then a $1 per rod annual payment. There could be different annual payments for different types of roads. I've seen where roads are defined as either major or minor roads. A major road being defined as one that serves 3 well sites or more. And a minor road being one that serves 2 well sites or 1. Compensation for major roads, at least the annual compensation, is usually higher. Compensation for pipelines and width. I didn't mention for roads, you ought to specify a road width. You ought to specify a width for pipelines, what the initial compensation is going to be. Usually there's no annual compensation for pipelines. Power lines, the compensation for power lines.